cooperate. Yeah, with the program.
Can you start faster?
No rush.
I'm still trying to think of something funny to say.
Now, imagine. Yeah, how about a lower marker thing?
Wait, so is this debate like going to be live stream or what?
Yeah. Do you consent?
I don't consent my face. I don't consent like you showing my face. So you can see. I don't need my boy seeing me wearing lipstick. I know I look beautiful.
He already started the live stream.
You know what? Never mind. Okay, let's go.
Don't see my boy.
Okay, never mind. Okay, never mind. Test.
How about you just?
What? For my family.
How about you just coffee? Yeah.
Huh? Okay. I didn't know that's part of it.
How many minutes? Sorry. You all know?
I was thinking of a funny opening to say, but I think the funniest thing that will ever happen in this debate is literally letting a biased panel of lay people literally decide the culpability of individuals in the trial process. Look, in this debate, we're going to show you one very simple thing, that the law needs to be as objective as possible, and the best possible way to do it is via the system of judges adjudicating culpability of individuals in this case. Note that the principle in this debate is the law needs to be objective. But why is this important? Because notice the trends in status quo that essentially is one that is adversarial towards the minorities who oftentimes face forced incarceration because of the very fact they're minorities. That like when juries literally see, like an all-white jury sees one black individual, one African-American individual, they're likely to convict this individual based on the cognitive biases that they already have from status quo. The comparative that we're going to defend is judges within this debate, and we're going to take that clash. But notice, on an overarching level, we also make the legal system better as a whole within the idea of objectivity in itself. Problem. Essentially, law dissemination via juries isn't objective. The very fact is, juries are also influenced by the same thing as you and I. The juries are oftentimes likely to be individuals who are susceptible towards cognitive biases, like believing that African Americans are just more likely to do crime. There is no real statistical data to show that these individuals are more experienced in providing clear adjudication. All the only unique benefit they have is, but they are people just like us. We don't think the unique benefit of them being lay people necessarily stands in a world that so badly needs justice, not just for the average reasonable voter, but for the minorities that have so long been screwed over. We think it's time for that reparation. Necessarily, we're going to change status quo by ensuring that even if necessary to make this concession that we have more judges, we're fine with that. And to a certain extent, right, judges direct the jury. So we think juries problematic, the problems of these juries necessarily still translate, even if judges direct these individuals. Okay, how do juries look like? 4 points to this. Juries have very limited use in status quo. Oftentimes they lie for cases like criminal cases, murder, robbery, assault, stuff like that. They also apply for some small subset of civil trials. I don't know, I took law 2 months ago. I probably forgot half the stuff. But notice, and this is the important distinction here, that the adjudication by a lay person versus a legal expert, it is more likely that the legal expert's adjudication is one that is more objective. And why is this important? This links up back to the idea of culpability on the third level, because this is based on questions of fact, like when was the murder committed? How was the knife covered in blood? Things like that. What the jury decides on is directed by judges, and necessarily these are questions that they have to answer. In principle, that just lies as the role of the jury, but an average person just like me gets to decide the fate of one of my countrymen chosen randomly. And we think that's harmful within this debate. Second thing, right, on the first argument, trial by peers, why there is never legitimate in any inherent scenario? Because notice that this might work in 15th century England, where everyone happened to be an Anglo-Saxon Norman person that looked the same like you. But in 2018 England, where literally your next door neighbor is a refugee from Somalia, you are likely then not to think the same way with regards to your adjudication. You are not going to be objective. I think I've already shown you in my preamble that how, as a all-white jury, you are likely to convict the black man based on false assumptions. What is the comparative that we're defending? Even if judges are straight, white man, Oxbridge educated, I don't know, my law lecturer like to say that a lot. Even if this happens, these judges are less biased because of the very fact they're educated in Oxbridge, the very fact they have legal expertise that you studied for to pass the BPTC for. Beyond that, they also exist in like higher echelons of power, like higher echelons of privilege, I mean, to some extent. So they're likely to get more access to information that just makes them more clear-headed about the things that they're adjudicating. So what happens then? Also, not just that like, they exist in like they're richer and shit like that, they are more open to live life experiences. Because the very fact is, if you have that kind of financial prowess, you're likely to be able to go out and talk to more people. So this is likely to make them more empathetic, thus taking the arguments of diversity as a whole. What is the final point there? The very fact is down because they are more cognizant of the lived life experiences of various diverse groups of people, they are also likely then to provide more objective adjudication as a whole, thus reducing the harms to minorities on a net basis. They have to defend a world where all the racist biasness of the status quo, where the jury system decides the literal fate of an individual. That is their burden in this debate. Second argument, with regards to the personal jury and how they approach this. I think it's very intuitive to say that a personal jury is likely to have come up for the first time, chosen at random from the voter roll. Whatever they see is something they see for the first time. What's the comparative in our world? A judge who's probably seen this happen like 70 times across his career. So in these 70 cases, you're likely then to adjudicate them based on the relativeness of these things. Like, oh, but like an African-American individual stole bread. A white person also stole bread. So when you consider these things, the jury sees this kind of actions happen and they're like, oh, my biases tell me these people of color are likely to do these kind of actions. Therefore, I must convict this individual. What is our comparative here? When you have a bunch of judges who've literally seen this 70 times and are able to think on the facts, he took this bread from Sainsbury, I don't know, yada, 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 he's likely to be able to filter them out to the most objective things. He's likely then to, like, if the punishment needs to be punitive, sure, he's then likely to convict on reasonable grounds. Because notice that systems of appeal also exist within the judicial system in case of unfair trials. So we take that clash in terms of objectivity and successibility. But the third argument itself, in terms of law. So law is made as possible, as be objective as possible in passing on justice to the people. We told you why juries are more susceptible to the subjectivity in the law. But there are two examples to this. The first applies towards lawyers. I think if you're like prosecution or defense lawyer, right, you're rich, you hire a guy who sounds like yarn, uses big English, he's more likely. Okay, but back to the point. He's more likely to persuade the average reasonable voter on that jury. The comparative is this. When the judge has heard the same thing happen 70 times, I think this counterfactual holds throughout the debate. You're likely to think, okay, he's talking a lot of stuff. Let's filter this out. Let's get down to the facts of the case. What is the conclusion in our world then? You're likely to get objective forms of justice with the way that the lawyers present this case. You don't provide additional powers that benefit the rich and make the power balances far worse. You even out these power dynamics. We get that unique benefit on our side of the house. But the second example then, beyond just how the lawyers would work, is on expert evidence. Like juries are very susceptible to this thing called expert evidence, where like you bring in this guy with a PhD, he says, I can read noses. So now he's likely, because the guy claims he has a PhD in reading noses, right? You're likely to take that as very legitimate and very strong empirical evidence to punish people. But who are the people being punished the most? Minorities. What happens when you put 1 + 2, you get 3? Because of the very fact that you believe the expert evidence is legitimate, you use it to back up your cognitive biases to unfairly penalize these minorities. Necessarily, you take them all piecemeal. Even in the best case, right, like juries do think a little bit. Don't forget that these biases are oftentimes overarching and very holistic in the way that juries want to approach these cases. So oftentimes you're going to get horrible results on a net basis. What's the comparative here? Judges are more well-versed with the exigencies of law and judge more objectively. The very nature of the fact that you heard it repeated multiple times means that you're likely to introduce yourself to these objects with just more objectivity to avoid false incarcerations, false convictions, and make a far better world with regards to dealing with justice. Law should be objective. Law is great. Propose.
The jury system is an archaic system that was created when societies were homogeneous, when judges didn't have much precedence and law to rely on when it comes to making their judgments, and they really didn't know much themselves. We have evolved multiple times since then. We have a wealth of cases to refer to. We have huge databases of previous arguments, previous cases that were run. We have huge databases of previous witnesses, previous criminals that were convicted. And with all that information only being available to individuals who are within the legal process, we don't think that lay individuals are able to make a fully informed decision as to whether or not someone is guilty or whether or not they are innocent. Now, I have a couple of rebuttals because Amrit just talked way too much with a lot of ridiculous arguments. But one thing I'm just going to quickly get aside very quickly is this argument that people will be able to adjudicate. Like when a law is ridiculous, people will be, in the trial process, they'll be able to not apply the ridiculous law. Like this just doesn't happen and this is impossible. Like literally the duty of the jury is to just say whether this person is guilty or not guilty. The judge will direct them, is this person guilty of penetrating with a penis in this particular situation? They have to answer yes or no using the word guilty or not guilty. They cannot impart or answer a different question altogether. I don't understand where she says this particular flexibility comes from. But the rest of the responses, right? So they say that they can add diversity in the jury and they can have jury vetting. Like obviously, these are things that currently exist in status quo. So even if you have a diverse jury, right, this doesn't deal with the fact that there's a huge amount of internalized racism within even individuals who are black, right? They're likely to feel that another black person is more likely to commit crime, and that internalized racism or sexism or bigotry or misogyny can all still exist. And even if you have a diverse reflective pool of jury, it'll still diversely reflect the majority of the individuals within the country, right? Secondly, in terms of jury vetting, the racist fella isn't going to post on Facebook that he's racist. Like you're unlikely to vet a jury to be able to catch these individuals who are internally racist or explicitly racist, because they're not just going to tell themselves whether or not they're racist, right? So her response to whether or not judges are racist is that, yeah, they're racist, but they're just going to be better at hiding it. So in a world, we would argue that at the point which people have equal opportunity to develop racial biases or tendencies, we think judges are more likely to mitigate the racial biases and tendencies or cognitive biases that they have. The reason for this is because they study for years in jurisprudence or even past precedents and cases with the existence of these things, right? So at the very least, they are aware that there are biases. They are aware that individuals are incarcerated disproportionately because of their race, and they are more likely to try and work against it, right? So I think in a world where if you accept everyone is racist, I think the judge is less likely to try and is more likely to be aware and move out of that racism. On top of that, we just argue that because the judges are just generally better educated, individuals who are better educated often are less likely to be racist. You can't have that certainty with a group of lay people because you don't know if they're better educated. You just take them randomly from wherever. The second thing that they say is that the people know better about the favelas in Brazil. The judge, if he uses precedents, is more likely to homogenize a group of people. He doesn't know people. He doesn't know society. This is just simply untrue, right? The individual who becomes a jury is likely to be the jury for the first time in his life. He's likely to face a criminal for the first time in his life, and he's unlikely to have faced the same situation in any other way. His lived experience is literally that one lived experience in the Bronx or in Compton or wherever, right? Those situations, that lived experience doesn't form a very informed consent, doesn't make you a wiser person, as opposed to a judge who has adjudicated an aggregate of cases, 70 different cases or 100 different cases of individuals with various different lived experiences who have to explain their lived experiences in the trial process, and the judge is more likely to be aware of it. I think the judge knows better about the people or the favelas in Brazil, as opposed to the random allocation of individuals from Brazil who may not even be from the favelas in Brazil. So the likelihood, the chances that the judge will know more about various lived experiences is higher than the random individual you're likely to allocate for the jury, right? Next thing they say is that there are privileged judges. and they argue that their lived experiences are poor. So again, I think they have a better aggregate and impression of various lives, and the jury select is likely to not have that same experiences, right? So lastly, in terms of judges being very elite, therefore people distrust the system. Like, I don't understand the analysis. She says, in the Bronx, people distrust the law because the law isn't helping them. But in the United States, the jury system still applies for all criminal cases, at which point she's just conceding that the people distrust the jury system right now, right? So at the point which we argue that you remove that jury system, I think you have a better trust of the law because you are less likely to disproportionately incarcerate black people because they believe that that system is disproportionately incarcerating black people. So in my speech, I'm going to add on one particular argument on how trial length often excludes the poor from justice, right? So what happens with the jury is that they unnecessarily increase the trial process and the length of the trial process, well, largely because they're idiots. And I think that this is problematic because it exacerbates the cost of trial for the poor. They go in and discuss for hours, then one fellow will be objected because he made a Facebook status which compromised the case, and then he commented about the case on a particular status, and then you will have to find a suitable replacement to create that diversity in the judge pool again, and then that poor person who's being charged for the crime cannot afford that particularly expensive lawyer. I think the reason why, like, a lot of times the law isn't accessible to the poor is because of the fact that it extends for so long and there's so many mechanisms for it to be extended for so long, right? We would argue that at the point in which you allow jury systems to, like, you allow judges to take control of the adjudication of the law, that's when you have a faster decision, and a decision that is likely to be more accurate, right? A decision that is likely to be based on precedents, a decision that is likely to be relative. So for example, if 10 years ago, in the same circumstance, I sentenced this white guy to 10 years in prison for that particular fact of robbery, then in that same particular fact, 10 years later, I will sentence this person guilty for 10 years of robbery as well. I think the difference is if it was a jury who has not viewed that case relatively to that white person who committed that crime 10 years ago, in that same set of facts, if that white person was found not guilty, the jury is likely to find that black person guilty today, right? So who can actually make the comparison? Because the jury has viewed that case one time, has viewed that particular set of facts one time. The jury has probably viewed that particular set of facts 20 times in comparison to another 20 set of facts, and is likely to be able to come to a better relative decision. So lastly, I think just have to answer, like, is a judge likely to be racist? I think even if, like, we're not saying that they're all straight white male, right? They are sort of mischaracterizing us in this little bit. Like, some of them are probably straight white male, Oxbridge educated, but even in those situations, we at least have some certainty that they are educated, have exposure to jurisprudence, have exposure to various precedences, have exposure to critical criticism from other judges, their other peers, academicians, and so on and so forth. Juries have none of that criticism. They have none of that experience. They are more likely to be racist, ladies and gentlemen. I don't understand why this comparison exists. Like, a judge doesn't need to hide their racism because they're just very good at not being racist to begin with, given their access to education. So if we had to choose between the certainty of one person being not racist because we have reasons to believe he is not racist versus the uncertainty of 12 people who are selected randomly and you believe they're not racist because they didn't post a Facebook status that they're not racist, I don't think that this is a safe choice. We would pick the safer choice of the judge adjudicating the case.
Sorry, do you mind if I run you a little? Thank you. same individual. Calvin, I think, has a very strange fascination with the consistency of law being an absolute good in every single circumstance. Before we move on into actually talking about it, I just want to be very clear about the kind of cases that we are talking about and what kind of changes a jury system could potentially make that the judge would not otherwise make. So let's put aside the idea of like racial biases right now. Let's just talk about how exactly juries might differ from judges, assuming perfect systems in both. Now, I think, firstly, while Calvin is probably correct in saying that juries are not able to make broad, sweeping changes to legislation with regards to the idea of like, you can completely change what definition of rape is within the law, I think what juries are able to do are still things that make significant impacts in the lives of individuals who are affected by these norms. So for instance, in the case of like stealing something from a store, for instance, a jury may potentially choose at that point of time to find a person not guilty at a point at which the mitigatory circumstances that they are in, they were poor, they were coerced, they didn't really have much education, etc. They might choose to come back with a not guilty verdict simply because they do not believe that the individual in question is actually guilty of a crime. This is incredibly important because the idea of who is guilty and the label of being guilty that is attached to an individual in the court of law is something that identifies the individual as having committed a wrong against society. I think in those circumstances, the ability of a jury to be able to deliver certain verdicts that say that they do not believe that these things are wrong is incredibly important for these individuals. But the second thing that I want to talk about is just this. Like, even if you don't really buy, you think there's no real reason to sort of preference one set of facts over the other with regards to what proposition is saying, what we are saying, I think that what we have to note here is that if all circumstances in terms of the law was as clear-cut as they would like to point it out to be, that a judge could accurately and relatively give the same decisions over and over again, the question then would be, why then do we have human beings being able to make these decisions if all that it was a question of fact patterns? Clearly, there must be a degree of subjectivity in between each individual and special unique case that allows for individuals to make some valid judgments about what they ought to prioritize in those cases. There was a precise point that Ami was trying to make, that those specific minute differences were things that ought to be decided upon by individuals who were in a jury who live the same kind of life, or at least a kind of lifestyle that's significantly more similar to the people who are being tried, or at least, at the very least, are individuals who are ultimately affected by the norms that come out of those courts, and are individuals who are from the community that are ultimately responsible for creating those laws to begin with. Why are judges comparatively a lot worse in doing that? We would argue that the precise arguments that the entirety of government was saying, that judges have tried the same case multiple times, and in fact that their legal training chooses to distance or forces them to distance themselves because of the number of cases they've seen from the humanity of the situation, the individual and the victims who are involved in those crimes, makes them in an incredibly poor position to be able to make those judgments. So even if you don't buy all the analysis about how they live in their ivory towers and how they are more privileged individuals, at least buy the idea that because they've seen so many different trials already and the experience of doing those things, they are far more unlikely to be in touch with the humanity of the situation and think about a victim in any way that is meaningful. We would argue that the introduction of that specific humanity and that emotion, that subjectivity, is actually a good thing, because we think that is what the law is, given that the law is a reflection ultimately of what the public believes in. But the third benefit that we are also talking about in this particular case, the reason why this is also a good thing is because in general, laws always take a much longer time to be able to catch up with what society wants and believes in. And in fact, this kind of lag could take years or even decades in order to catch up with it. And the reason why is because to overturn a precedent requires you to find someone who is outstanding, who is willing, for example, to be able to fight the case in court to overturn those precedents before you can get any sort of change in terms of the kind of interpretation of those laws. That requires a huge amount of money and a huge amount of time to be able to do. In the comparative, we think juries who are currently living those particular lives are able to immediately give those kinds of different decisions. They are much more in tune with how society believes the law ought to be at that specific point of time. The question therefore that we have to answer, given that we've established this, is in that situation, would it be more or less likely that these individuals are going to be biased, and or will those decisions that the juries or the judge come up with going to be biased, and are they going to be the correct or better decisions that are actually reflective of the community? We're not going to say on our side, obviously, that we stand for racism with communities, like stand for racism. But what they fail to recognize is that the value of the numbers in the jury is in and of itself a very indisputable good. Because you just think about about it in terms of like commonsensical numerical numbers, the ability of one individual to make a wrong decision or to be biased in favor of something that they believe in is always going to be greater than the need to have a unanimous decision from 12 individuals that a person is definitely going to be guilty, especially considering that saying that someone is guilty requires you taking away rights and freedoms that person has. So if you only have one judge and the judge happens to be biased on your side of the house, you have no check whatsoever against the individual, especially given, as Ari has already given you analysis about why is it that judges find it a lot easier to hide that racism behind legalese jargon. That is incredibly difficult for individuals, especially the poor individuals you're so concerned about, to be able to fight back against. In the comparative, juries have a large number of people. That's literally the reason why finals panels, for example, have 7 people, not just one, so that one individual is not in charge of the decision and the fate of the person who is at hand. But also, let's talk about institutional racism, because I think that the responses coming from Affirmative were incredibly flippant. They argue, well, there's still internalized racism, so therefore, as a result, the entirety of society is going to be differently racist against certain individuals. Like, internalized racism might sound like a nice thing, but if you think about it, if you're an African American and you literally live through the entire idea of being discriminated against all the time, you are probably in the place in which you are the most likely to recognize that you are unlikely to also be a thief, or you don't think that you are a thief because people don't generally think that they are the worst off people, or if you don't care or you have a low opinion of yourself, you're unlikely to think that your friends and your family are also going to be people who are similarly more prone to crime. I think that is an important countervailing and diversified view, and that is the reason why internalized racism is not an argument that can be used to say that the jury is going to be uniformly racist. I think the diversity of those opinions is able to very effectively counteract each other within the confines of a jury, which have multiple opinions that are being talked about and multiple votes that ultimately decide that verdict. In the comparative, the judges that you are talking about are much more likely to be racist simply because of a lack of interaction or understanding of what any of these other lived experiences are like. Their alternative to this was, well, they've spent many years listening to different lived experiences, therefore they have a better understanding of many different people's kinds of lives. But I would argue that while that may potentially play a part, firstly, again, we already told you why judges are far less likely to be sympathetic towards these kinds of stories and much more likely to create some sort of epistemic distance between themselves and those ideas. But also, secondly, the idea that they've just never ever lived through it. Whereas in a jury, even if not everybody from the favelas of Brazil, maybe 1 or 2 of them are, and they're able to interact with the rest of the jurors during discussion, and they're able to make votes as a result of that. We think that is a far better alternative than the one that they've put up on their side of the house. So comparatively, I think it's far more likely that a jury is able to check each other when it comes to the idea of racism, rather than the idea of a judge who's able to not just be racist, but are able to fight back against any sort of scrutiny against their racism by hiding behind the legalese or the education that they are in. At least jurors are everyday men. They are not able to hide behind these things. It's far harder for them to defend themselves against those kinds of things. Lastly, this idea of exacerbating the cost of trial, I think it's just a trivial argument, because Kelvin says like, oh look, like, you're not going to make the trial so long because jurors have to go like wait, etc, etc. Look, here's the thing about having judges. When you have a lawyer, it is literally a strategy in law for lawyers to unnecessarily lengthen the time of the trial in order to try and bankrupt or find more time for themselves to get the evidence. They do this by like filing random delays to look for facts and etc. And judges are willing to do this because it's just part and parcel of life. A jury that does not have such habits, for example, or does not have such like nonchalance towards that case, is probably unlikely to look favorably upon an individual or a lawyer who tries to unfairly prolong the period of time of the trial. So at best, these arguments are washed because both sides have an interest to lengthen the trial process. We're very happy to.
You're here.
So this debate started out as a discussion on which party would be more objective, and then subsequently it went into a question on who should decide culpability. And a few things to say under each issues. But I'll start with who should decide culpability, because in our speech she says that it's the people who should decide, right? Because it's why we have the parliament making a law, because parliament is an extension of the congregation of people. They make law, therefore they should decide how this law is applied. Now, my question is, if that principle is true, then the party making the law shouldn't be the party applying it. We call this separation of powers, right?
Yeah.
So then, and which is why the subjectivity that appeared that Shermaine seemed to want to push for in her speech is particularly pernicious, right? Because the subjectivity in the application of law we think is harmful, we think certainty is great. Because what Shermaine suggested to you was that, juries can make small changes. Okay, so if the aggregate of society is sexist, is racist, then the small changes that you say will happen probably won't happen, right? They'll choose like the outcome that fits into their biases more, right? And we gave you several reasons why these biases exist, right? As if you are a part of the majority, you're more likely to be biased against the minority, and and because of the numbers game, your panel of jury is more than likely to be from the majority, right? So then she wants to say that, these small changes can have lasting impact, as if but the problem with this is that precedence only applies to judges' judgments, right? So I don't see where this impact of these small changes in decision made by jury occurs in his speech. I don't see the impact of this. But the thing is, the link between the statement that people decided what the law is, therefore they should adjudicate it, doesn't exist, right? People create the law. They elected people to create the law, and they consented to the law being adjudicated by the judiciary, right? So there's a separation there. We think this separation is important, because what this means is, at the very least, even if we trade off, even if that means that there are no changes, even if the changes are great, at the very least, we have certainty in law. And we think the certainty in law is great, right? At the very least, you know what you're in for. You know what is the outcome of your action. You know, basically, you can meaningfully consent to whatever it is you choose to do, because you make an educated knowledge about the outcome of whatever the punishment if you decide to do whatever action. We think this is important. If it is uncertain that this particular action will lead to this particular outcome, then we suggest that the choice that you are making in that decision isn't valid. You're not making an educated choice of what action that you want to take. Next, she thought about how this idea of how having a larger number of juries is fairer. That's only true if there's no bias, and we've given you multiple reasons why they are likely to be biased. So where does this leave us, right? So where does this leave us? This leaves us this leaves us with this issue of, in which world are we less biased? Because a lot of the benefits of the juries are contingent on them being more objective than the judges. We don't think that's true. They said, if you're a judge, you're likely to be privileged. You're coming from likely straight white male family background, and you are likely to have stronger biases against the minorities. But it's not true, right? We told you on multiple levels that because of their aggregate experiences adjudicating many cases, like this biases will be eventually diluted. We told you that because of the high level of education that he probably has attained, is more likely to be on the liberal side of things, right? Like just pick a stone, throw it in the streets of London, you probably hit a liberal. Because like in the streets of Oxford, you probably hit a liberal, and you know, because because like the higher your education level, we think like it's more likely that you are more liberal, and therefore you are more likely to suppress the kind of biases, and because you are aware of them. Secondly, and next is this idea that we have, that we told you that because they are well versed in adjudicating, they are well versed in jurisprudence and all, they're more likely to be able to know the nuances in each case, right? That separate guilty from not guilty, right? Because there are very subtle things that determine these things. So at the end of the day, there's also this, at the end of the day, it's about why law needs to be objective is that at a point in which it ceases to be objective, there's the harm of it being unfair to minorities. And that's why we need law to be as objective as possible. That's why we need the party that has the least biases possible to be the one adjudicating culpability, right? So in which world do you benefit the minorities? We told you that as a result of judges being more objective and being more able to suppress their present biases than a collective or a random collection of 12 people, they are more likely to be objective. They're more likely to give the minorities like a fair trial, a fair result, right? And Kelvin has also told you that as a result of the removal of jury trial, the court trial also becomes significantly more accessible to the minorities. I think this is important, right? And like they never really came back from this. Like because at the point in which your lawyers or whatever it is decide to make the trial longer, it's only enabled by the fact that they are determined by which not used to use as juries and all to lengthen to make trial process longer. So we think the jury system is horribly efficient, it's horribly, it makes the court process horribly expensive and inaccessible to people. It's bad for folks. So at the end of the day, we see that the jury system is less objective. We see that subjectivity in law that is perpetuated by the jury system is horribly unfair, and it's really bad for minorities.
Three issues in this debate. Firstly, the principle. Secondly, the process of adjudication and empathy within it. And thirdly, racial bias. Firstly, the principle. Let's notice that proposition has absolutely ignored the principle coming from Amit. Because the idea was that given how laws originate and laws are applied, they ought to be applied by the common people and how they interpret it. Which is to say that if you look at the anatomy of crime itself, we say that crime is committed not only against the victim, but also against the community. And there's a reason for that. Crime being committed against the community means that whenever a particular person is committing a crime, that person is committing a harm to that community. Now, in principle, who should be the people adjudicating whether or not this crime was indeed committed and whether or not that harm was indeed inflicted within the community? It's the people of the community again. And that's why the trial by peers or the trial by the jury system came about. Because we wanted the people to decide on a conclusion of whether or not a particular person was guilty or not. weigh up with this principle against some sort of objectivity that they talk about. Firstly, objectivity cannot be guaranteed, by the way. Nobody in this particular bench compared and contrasted how actually judges all over the particular country will be the same and absolutely give us same judgments all over. We say that we understand that yes, in certain cases, judges themselves might be consistent to the rulings that they're doing. But there are certain things that separate one judge from the other judge, and so on and so forth. We say that we see within the Supreme Court, for example, there are judges which have a liberal bias versus the judges who have conservative bias, for example. Certain judges are more tough on crime and certain judges who are not tough on crime because based on ideological differences. We say that judges themselves cannot be objective in principle. However, our principle in comparison is a solid one that suggests that the community, through a system of a trial by jury, should be the one who is deciding it. We think this in and of itself clears out the cloud in case of the principle. Opposition takes it very clearly. Secondly, in terms of the ability to adjudicate and empathize, and this is where I'm going to also consider objectivity yet again. But first, let's talk about relatability, because this is something that came as a goal from the first speaker. They said that we want people to be able to adjudicate based on the lived experiences. My first two speakers have already explained to you why lived experiences are better served on the jury. But let's just look at it from a very analytical perspective, right? Recognize a judge, best case scenario, is very educated, has a lot of experience in law, and has seen a lot of cases. That person's ability to be able to relate to a particular case that, again, we have argued is very unique in circumstance. But even if certain circumstances are overlapping, there are certain circumstances that are unique, versus a particular group of 12 people randomly selected from different socioeconomic groups. At least one or two of them are likely to be able to relate to things. Why is this so very important? Because if you look at cases in a lot of instances, what is more important than objectivity or looking at it from a crime's perspective is empathy, which is to say that when you judge a crime, you need to look at the motive of that crime. You need to look at the emotions behind that crime, whether or not that person is actually pleading in a lot of instances self-defense for a particular, for committing a particular act. These are all circumstantial situations through emotions that a particular person has to judge. Now let's compare a world where lawyers have to pander to a judge versus lawyers having to pander to a particular jury. Lawyers, when they have to pander to a judge, do it on the basis of precedents or jurisprudence rather than what the actual emotions of the case are. Because they're likely to study on what the precedences were. And they know that the judges also prefer precedents. This is by the analysis of the affirmative team. Would you want that world, or would you rather want a world where the lawyers are actually pandering to actual human beings with emotions and laying it out to the layperson how the law should work and whether or not this person is actually guilty on both an emotional level or secondly on the level of motive and actually accruing a harm to the community? Would much rather prefer the second world where rather than pandering to the specific biases of the judge, this is both the lawyers trying to either look up on cases that the judge has already done and therefore pander to the specifics of that particular judge, or looking at certain cases that have been dealt with before. This is a system of law that they are advocating for versus a system of law where, yes, these individuals are new. Yes, these individuals have not sat in the court of law before. But these individuals are able to see from a common rational person's perspective whether or not a harm was accrued to a particular crime that was done on the people. Secondly, we think in a lot of instances, the discussion that is so inherent to the jury system allows for that discussion to happen on, like in certain instances, certain jury members, we understand, may not be able to get the sort of discussions that were happening within the courtroom. Other jury members are then able to compensate for it and explain it. Now let's do a balance of probability math. If by any chance the judge is absolutely unable to relate to the case, then you're likely to get a judgment that is unfair. But the probability that any 12% of that jury is unable to get the actual emotions and empathy of that case is very low. We say that one person is able to then convince another person, and therefore the discussion in and of itself is likely to give you a result that is more empathetic, that is more relatable, and that is more fair. We tell you that fairness comes through this system rather than a system that's so highly dependent on precedents. In terms of racial bias, let's understand this. When Amrit told you that there was a inability of African Americans to relate to the system, she told you on the basis of the fact that it's statistically shown that white males and black males get different sentences for the same crime, which is to say that the black male is likely to get 3 times the amount of sentencing that a white male gets. And this is most easily demonstrated in the Brock Turner case, where if because of the rape of a particular woman, the judge sentenced him to only 6 months of jail. The reason this is a problem, this goes against them, is that now you are giving the entire system away to the same judges who decided this sentencing, right? The jury decides whether or not a person is guilty or not guilty. The judge decides whether or not a person, how much sentencing a person requires. The problem within the system is because of the sentencing system that is done by the judges, which shows A, the judges are biased. B, education in a lot of instances cannot go against biases. Why is that so? In a lot of instances, racial bias is not absolutely explicit. We say that you're not directly calling out African Americans inferior, but rather you yourself feel that they're inferior because of the way that you've seen society and social structures occur. The reason someone who is more privileged is likely to think of that is because they're less likely to have felt the sort of problems that African Americans face. So, for example, the fact that African Americans are more likely to commit certain types of crimes is because of the socio-economic problems that they go through. And these socio-economic problems are less likely to be understood by judges who are never likely to live, for example, in the ghettos, actually interact with actual African Americans and be empathetic of those experiences. And these are subtle biases that are ingrained within the system of these people who have been within the realm of law and nothing else their entire lives. Compare that with a jury system, where even if 1 out of the 12 individuals is an African American, that person gets a specific amount of time allotted within the discussion where that person is likely to be able to explain the biases to other people. Which is to say that even if there is a racist juror, that person is less likely to get away with their racism, because guess what? That person has to convince 11 other people that their racist point of view is actually a true point of view. Compare that with the lottery of having a racist judge, which Amrit already explained why they are likely to be able to hide the racism under the veil. And lastly, this external idea of dragging out trials. We think the judge system rather has more dragging out of trials, because the judge system literally has different levels that you have to go through. Like if you have one adjudication, then appeal system is there. You have to go to the federal court, and then the district level court, and then the national level federal court. These are endemic to the judge system. But oftentimes, you don't have appeals within when a jury has given a verdict, because the respect towards a jury system is absolute within countries like the United States of America. Extremely proud to oppose.
Thank you. I start with the negative one. In a world where we recognize that all humans are imperfect and ultimately that our law has been decided by human minds, the question that we therefore posed to the debate today was the question of whether or not it was easier for us to ensure that judges were consistently fair and consistently unbiased, and that we were able to structurally create judges that were far more likely to give consistent and empathetic verdicts, or whether or not we ought to hedge ourselves and ensure that we had a number of people to check and balance against each other with regards to their own lived experiences against different biases that each other might have. No, they're on the affirmative side of the case today. All that they did was simply assume that because judges were educated, therefore it was a carte blanche that these judges were going to be fair. They never responded to Amrit's characterization that over time, given that judges have been around for a long time, they tend to be very nepotistic in the way that they choose their judges. They tend to select other judges that propagate a similar view or a similar bias that they have. They never talk about how lawyers over time get to know different judges, get to know the different biases of different judges and play to these people, therefore resulting in far more unfair verdicts on their side of the house. Our solution to these forms of nepotism and these forms of unfairness and bias was to introduce a jury system where individuals were judged by a panel of his own peers, individuals who actually came from the same background that they came from. Maybe not exactly the same, but definitely more alike than an individual who was educated overseas, earns a heck of a lot of money every month, and only talks to other individuals who are like him. That was why we said that if you were to compare the two, the question of racial bias undoubtedly would have fallen to our side of the house. And that was the main contention that came out from side Affirmative. Because we told you that racial bias, even if existed within the jury, is likely to be checked. But more importantly, that the consultation process between the juries is far more likely to expose racism rather than allowing for a judge who is able to hide behind the technicalities of legalese in a way in which nobody else is able to pierce through other than other individuals who are also similarly judges that they presumably are very similar to and come from the same background. Now, what then about the principles of law if we recognize that it's more likely on our side that these biases are likely to be taken away? If we were to give them the benefit of the doubt and to talk about how these biases perhaps don't really exist in judges on both sides, then what exactly should the principle be when it comes to the sentencing? I think the other side of the house said certainty is good. And the reason that they gave for it is very clear. Because then you can meaningfully consent to doing crime and know the kind of punishment that you're getting as a result of it. But what we told you on outside of the house is that there is no such thing as a punishment or a particular verdict that is necessarily perfectly the same in every single case. That each individual case is different and came from a different individual set of circumstances. That the family income that you have might be different, that like the place where you grew up in might be different, your race might be different, etc. There were a bunch of different things that we considered to be different each individual case. And therefore, a result, we said that each individual case is to be adjudicated on differently. And the difference, we said, was important when it came to the ability to empathize with these individuals. So let's draw a comparative between certainty in law as being a good thing and a humane and empathetic application of the law being a good thing, given that we gave you some reasons as to why judges are more likely to be distant, and they also considered to that. Firstly, we would just posit, and we already told you, certainty is not an a priori good, given that oftentimes the certainty in the law that is reliant on precedent is a reflection of the fact that the law itself is something that tends to be very slow, that does not actually follow up to the mores and the ways in which individuals and the community values evolve over time. So certainty that they are speaking about could very well just be stagnation of the law to not reflect what people wanted. But secondly, we also said that there was no actual certainty because at the end of the day, the lawyers being better was still something that was able to change judges' mind. The last response that they had was, but it's about separation of powers. The person who makes the law cannot be the person who applies the law. That doesn't make sense. That applies for politicians, so that governments don't randomly go around just being able to give any sort of verdict to anybody. By the end of the day, the politicians and the government and the police and everyone else is still answerable to the community that voted them in and the people who are paying those fees. So if we were able to randomly select and randomize the fact that these would be the same people who are creating each step of the law, we think it is this. Thank you. Our final speaker of the day.
How much she studied? What she's interested in. Okay, yeah. So this is contingent on that. All subjective thing. Good job.
I'm going to talk about three things. The first, who has a better informed choice? Secondly, the principle. And thirdly, what they didn't engage with. The first, who has a better informed choice? They argue that 12 people are likely to be diverse in their lived experiences. We said they have no certainty of this. All 12 people can be subconsciously racist, sexist, and it's quite intuitive to believe that the preponderance of society subscribes to some form of stereotype or another, right? If you take a bunch of judges and you take a bunch of jury from the state of Texas and adjudicate a black person, then you're pretty likely to come up with a bunch of racist people, right? No offense to Texas. So what we told you in comparison is that the judge has some factors of certainty associated to him, right? He has education and crucially some self-awareness about the pre-existing stereotypes and biases within society as he studies jurisprudence. He has criticism from his peers. There is some certainty of him being beholden to the law. They say you can hide behind technicality. I don't understand this. The judge has to write a judgment about why he judged that way. The jury doesn't have to do anything. They just drink coffee after they make the judgment. Like, he at least has some level of accountability. The jury has no level of accountability. They say, but no, it's great that the jury has no accountability because it's not beholden to the law. They can fix the law a bit here and there. But what do we say to this? You can't really fix the law, right? Because you're given a duty. You're supposed to adjudicate whether or not this happened. And if this happened, the person is guilty. If it didn't happen, then it's not guilty. So there's very little flexibility to do anything. So even if they say, oh, it actually happened, he said, no, it's not guilty, that decision is not binding, right? It doesn't have to be followed. But also, this decision is not something that they can have control over the sentencing, right? They can only decide whether or not the person is guilty or not guilty. On top of that, that assumes that their decision won't be biased in how they make that small changes, right? They won't be racist, sexist, or bigoted in how they make those small changes. You can vote for a more sexist outcome if it's truly possible to vote for a more sexist outcome by finding the guy not guilty of rape, for example, because a large cross-section of society tends to be victim blaming in how they view women, right? Or how they view rape cases. Secondly, the principle. People made the law, so they should decide the trial. We argued that there was no link here from side government as to why this is so. And we also established that people also consented to adjudication by judges, right? So if they consented to the law being made by parliamentarians, they also consented by the social contract with the judge adjudicating the law for them, right? Because they can consciously support an anti-discrimination law and still be subconsciously biased in how they apply that law because they're subconsciously racist and biased in adjudicating. Lastly, what did they not engage with? We argued that they are more susceptible to rhetorical lawyers. The judge is more likely to catch out this pandering because of experience, very little response. The second thing we said is that they are more susceptible to questionable evidence, and this came out in Edwin's speech, right? So even if there is no racism, everyone is equally racist, these are all the fundamental flaws in juries that you just cannot weed out, and judges are more likely to fix it on a comparative, right? We also told you that it's likely to be longer, the cases are likely to be longer. Shermi's only response to this is that lawyers will make it longer anyways. Yeah, you're correct. The debate is a comparative. You have lawyers and juries making it longer. We just have lawyers making it longer. So therefore, the length just reduces, right? So in conclusion, right, I think we managed to prove that we have multiple reasons why we can be certain as to this one person's ability to adjudicate those trials. They have not provided us good reasons as to why we can be certain that these 12 people will be able to freely and non-biasedly adjudicate this trial as to someone's credibility and the ability to be credible. They just hope that the 12 people might keep a check on themselves and might have that discussion between all of them. Even if none of them are racist, they are still idiots who will be susceptible to expert evidence, who will be susceptible to things like a rhetorical lawyer who will make them change their decision. And that's why the legal process is not very accessible to the people who are poor, people who are minorities, people who don't have access to the system. We had argued that even if the law is more homogeneous on our side, that homogenization is good because the verdicts are often consistent. They are certain. You know what the law is. And it's fair in that sense. On their side, they allow room for the law to change. And that law is likely to change, not in the favor of the majority, not in the favor of the minority, but likely in the favor of the majority. We are happy to propose. I don't know what you're talking about. You are equally guilty.